everyone. Welcome to another episode of the AfricanMusicLaw.com show. I'm your host, Miss Uduak. This is the 167th episode. If you are joining us for the first time, let me tell you who we are, what we're all about, and how you can subscribe to the show. So, who are we? The African Music Law Show focused on empowering the African artist, wherever that artist and artist, broadly speaking, can be found. So, on the continent, in the diaspora, everywhere. Essentially, that's what we do. We empower. How do we do so? We do so through legal commentary and analysis. You're going to get a taste of that today if this is your first time joining us. We also bring industry professionals, a lot of them from our community, the African Music Law community, and they join us and share their expertise and insight, all of which is to educate, empower, and of course, propel the industry as a whole forward. So thank you again for joining us. I'm excited you're here with us. So far, so good. This entire year, we've been doing a lot of interviews. We have had some roundtable discussions, or a few roundtable discussions on legal issues in the business of music and entertainment. But at the core of the brand and the brand's identity from day one, we were established back in 2011 and set up the podcast in 2014 and live stream, as you're saying, just last year. So at the core of the brand is definitely legal drama, talking about the lawsuits, analyzing them, and talking about the issues when you're in the industry that you can see from a legal standpoint, and particularly the courtroom battles, so that you can prevent it as an industry stakeholder and certainly as an artist as well. So my background and why that interests me and why I've built a brand that's focused on particularly legal drama is I've been practicing law for almost 20 years now, and I'm a litigator, a trial lawyer, as much as I am a deal maker as well. The bulk of my career has been litigation work, so trial work. And certainly in that capacity, I've had to see and continue to see how people can prevent even getting into the courtroom in the first place if they dot their I's and cross their T's and do what they're supposed to do, especially in the entertainment industry. So for me, it is of particular interest, and I find you all, based on the metrics and stats and the longevity of the brand, are completely aligned in terms of let's learn what we have to learn so that we don't keep repeating the same problems over and over again and not getting resolution. And then it's a lot of headaches and lots of money spent. By the time you get to a lawyer and you say, hey, lawyer, can you represent me because I've just got sued or I have to sue someone? It is a lot of money, a lot of stress involved. So the goal here is not only to educate you, educate the industry at large, certainly help you so that you can try to prevent those kinds of unnecessary fires that you might have in your business, in your personal life, with the people you get into bed with, so to speak. So thank you to everyone that is joining us. I see some comments coming in. Umoran Samuel joining. Thank you so much. Tell me, Umoran, where you're joining us from. We do have LinkedIn folks. Let's see. We've got LinkedIn, YouTube folks, Facebook folks as well that are watching. And this is obviously also extrapolated and turned into our podcast. So podcast listeners will be able to hear it on all major streaming platforms. Let's also just get a few things. Oh, okay. Maureen is watching from London. Awesome. Thank you so much for joining us. We are getting ready to get started officially. Let's get some things going on here just on the general on how to reach us. So you can sign up for our newsletter at africanmusiclaw.com. It'll keep you plugged in to the community. We have our weekly newsletters that go out on a weekly basis. So that will allow you to get plugged in again into the community and be up to date on what's going on. You can certainly, again, as I said, subscribe to the show on all major podcast streaming platforms. Please feel free to rate us on Apple Podcasts specifically. That also helps with the search engine optimization so people can easily find us. And then throughout this entire live stream and on the podcast or live stream podcast show, if you have comments, and Maureen already demonstrated that you want to share, please feel free to leave that comment in the comment section, and I'll be able to pull that onto the screen so that I can read and see what you have to say and share with others as well. Having said that, before I get into what will be a very interesting show parsed out, I think I'm going to take breaks incrementally so that it's not too much for you all to digest, especially since I'll be delving into the law a lot more today, just like I did last week. But before I do that, a disclaimer. Yes, I'm a litigator, a trial lawyer, etc. As I talk to you about it, I'm a lawyer on the deal making side, fashion entertainment law. But whatever I say here and do, it's for informational purposes only. The African Music Law brand, it's a publishing brand talking about legal stories, et cetera, et cetera. If you have your own specific case, your own specific matter that you're looking to consult with an attorney for, or you're interested in having me work with you in that capacity, feel free to visit my law firm website. It's located at fashionentlaw.com. And with that, you can certainly, contact me, complete a consultation form right on the front end on Fashion ENT Law, and I'm happy to take it from there with you. But this is not a direct attorney-client relationship. It's just for informational purposes only. All right, we're ready to begin. And the place I want to start is just a general news coming from the continent that I thought was so important to highlight. Then I want to get into a very interesting lawsuit or potential lawsuit out of South Africa with the global hit Jerusalem. And then I want to get into the Yeezy lawsuit and wrap it up with the Tarantino lawsuit. So let's start first with news stories, and I'll be coming in and out with images I'll be showing. The first thing that I want to talk about is the Davido case. Davido just donated 250 million naira, which roughly in the conversion is about $600,000 to orphanages across Nigeria. And just before I continue with that, let me do a quick brand here to have him. Okay, so that's Davido, for those of you who may not know who Davido is. And the reason why I thought this story was interesting was that Davido essentially got on social media some few days ago and said, "My birthday is coming up, and if I've ever provided you with a hit song, friends, donate 1 million naira each." What he did not expect, according to him, and the response by everyone, since that went viral to the point where mainstream Western media was even covering the story. I think BBC estimated £300,000 was donated to Davido. But the reason why that's interesting is because once Davido put out that, you know, basically help me or plea for people to give him money. What was interesting was fan base, industry folks, and just everyone was donating. And I think it's particularly unique, according to Davido, and I agree with him that some of the people who donated didn't even have that 1 million naira. Some had maybe 60,000 naira, 100,000 naira, but they felt it was so important for them to donate to Davido. If this is your first time hearing about Davido, or you're aware of him, but not necessarily his charitable works, he's an Afro beat, or let's just say African musician whose work tends to be more in the area of Afrobeats, Afrofusion, and is certainly one of the leading pop stars out of the continent with global hits and recognition across everywhere. And what is particularly special about Davido that most people objectively can agree on is that he has a big heart and has done and donated a lot to charitable organizations, both on his own personal end as well as just all kinds of third parties. So I think it wasn't unusual to see the response that came. Now, of course, when such a charitable situation happens, everyone jumps on it. So you did have other celebrities saying, "Hey, donate money too if you can donate to Davido," and their fans donated. But what Davido did with all the donations was take all of that and now turn it over to charity. And interestingly, I think he said the total was 200 million naira. So 200 million naira Nigerian money. And he's adding an additional 50 million naira. So that's a total of 250 million naira that he's donating. I'm going to put a statement here. He essentially has a committee set out, and those committee members are responsible for looking across Nigeria, figuring out which charity organizations are best suited for distributing the money and ensuring that it's distributed. There's transparency, among other things. I think that's amazing. He says he wants to continue to do it on a yearly basis on his birthday. And I think that's what continues to endear him. And from a brand standpoint, although it doesn't appear he's doing that for publicity or marketing or promotion purposes, but certainly for everyone watching, beyond the fact that it's obviously good to do good, but I think also you create a public goodwill. You strengthen your brand in the public when you are truly, genuinely giving back, not necessarily expecting things in return, but then you see how your fans can respond because of your authenticity and consistency in giving whenever you can. And Davido is definitely a good example of that. I'll just briefly flash his statement that he released and what he's going to be doing with the particular funds and the committee he has. So wait. All right, so that's Davido, the first news I wanted to talk about that we have down. And then the next story that I wanted to talk about is the Peace Square story. After almost, let's see, and I'd love your input on this as well. So keep your comments coming from Umorin to everybody else, wherever you're watching, Umorin in London, etc. Thanks for watching. And feel free to, leave your comments and keep it coming. So next thing I want to talk about before we get into the lawsuits and the key issues to really be concerned about is the P Square story. So P Square, after the band is reuniting after 4 years of a bitter falling out. And I'll tell you all very briefly why that fans across the African continent and in the diaspora are rejoicing. P Square, if you do not know who P Square is, there you go. Those are who P Square, two band members. They are twins. They have been together as a band for over a decade. And unfortunately, about 4 years ago, roughly about 4 years ago, they had a very bitter falling out at the point where they should really be enjoying all of their hard work. I think they're going on 2 decades of being together, but like in terms of really brand momentum on a global level, the past decade they've been really enjoying it, and the time when they should really be like moving things forward, where Afrobeats is now getting recognized and they were at the forefront of trailblazing that path, they end up with a very bitter dispute. And why is that relevant? As you can see, they're twins. Not only are they twins, they basically were tied to the hip for everything. And I don't think fans ever thought they would ever see not only such a bad breakup in the African continent, specifically to the African entertainment industry, but I don't think they ever thought it was possible that twins can have such a bitter falling out. But it is possible. And one of the key reasons in that particular relationship, which is well documented publicly by both sides and what they had to say, a lot of that was not having their business structure, infrastructure in place, and really operating more so from a perspective of family business. So it's a family business, and dotting I's and crossing T's were not in place when they should have been in place. So a caveat to all of you watching and a caveat to all of you listening, whether family, friends or not, it is always important to get that paperwork right, have things in place so that you can preserve the relationship. As uncomfortable as it may feel to have your spouse or your sibling, etc., put things in writing for, let's say, distribution of music, incorporation of the business, who's going to operate it, bring in new shareholders into the business, investors, etc., corporate structure, the whole 9 yards, right? As much as it might be uncomfortable to do so, trust me when I say, and from a standpoint of someone who has had to deal with representing people, family members included, that are in like people who come to me for representation that are families and having really, really bitter fallout. I can't stress it enough. It's super, super important to dot the I's, cross the T's, and yes, be uncomfortable so you can be very comfortable in future. So it's really good. Fans are really excited. Congratulations to them. They could finally come together. As far as I'm concerned, it was only inevitable. it makes sense they would come together because they're losing so much money on the table because of their inability to work things out. So good to see that they are working things out and finally moving this needle along, because they have been so monumental in the movement for Afrobeats, and it only makes sense that they should be able to enjoy the fruits of their labor, and that's not going to happen with a divided house, so to speak, and a very bitter split. So congratulations to those two again. All right, so the next story that I want to talk about is the Mo Abudu story, a very interesting story that I also think is important to give flowers to Mo. So Mo Abudu is the CEO of Ebony Life Media, and she has officially partnered with Harvard University, out of here in Boston, out of here in the US, in Boston. And specifically, they have launched a Harvard Business School case study. And you can see that on the screen. Mo Abudu's Ebony Life Media is officially a Harvard Business School case study. And to my knowledge, it's the first African woman-owned business or African-owned business that's become that has the privilege of being a Harvard Business School case study. And if you don't know Mo, let me just put her image up. And this is her at Harvard Business School, where you can actually see her. And I'll just talk a little bit more about her accomplishments very briefly. All right, so that's Mo Abudu for you, and several things. As we know, a lot of Africans know that. Certainly, those that are involved in foreign direct investments on the continent know this, whether large corporations, medium size, etc. There's a consistency with the challenge, immense challenge of doing business on the continent. Number one key issue, if you're talking about a market like Nigeria, is power supply. It is really really amazing that some of the businesses there are able to survive when you're completely reliant on generator in order to power your business. Forget the pollution and all that goes with that. Imagine the cost alone of just operations under those circumstances. And then when you add the reality, whether we like it or not, and if you're watching this, I happen to be of Nigerian heritage. I was born here in the US, but I grew up in Lagos. So I'm familiar with the realities of also a patriarchal system that is not in any shape or form favorable for women. It's a completely very, very challenging climate. So you've got business operations very difficult to even, whether man or woman, to even make business work in Nigeria. Then you add the gender factor as well. Then you add the industry, right? Media company dealing in entertainment. For the most part, entertainment is seen more as a cultural experience than one that needs to be monetized or create a business around it. And for this woman, particularly Mo Abudu, she's been able to break barriers left, right, and center. Not only has she been able to pull through with creating a media company that's been likened to Oprah, but she has also even built out. I think she now has a theater she's built out. She's expanded operations to a very large campus. She's had a lot of industry folks. She's really, really created a pipeline as well of from young attorneys to everyone across the value chain. And then she's taken it a step further by entering into interesting deals, so to speak, and for many times the first to do it with respect to Hollywood studios that she's brokered deals with, from first look deals to all kinds of diverse deals that she's brokered. Amazon, Universal, Sony, I believe Universal as well as Sony, among others. So it's so good to see her charging and moving forward. She's had all kinds of screenings, both in the UK and other markets. And so it's really, really commendable that right now Mo Abudu's Ebony Life Media is officially a Harvard Business School case study, where she outlines how she got there, and people get to see, understand it, and maybe even propose how to better improve what she's doing for longer sustainability. So that's the Mo Abudu case. The next case I want to talk about, very interesting case and a lot for you artists particularly to learn from, is the case of, let's see here, the Jerusalem lawsuit. So let's put that up. All right. So this is out of South Africa. And if you're reading the screen where I have it, Biblos and Shamza, the DJ, versus Mastercraft KG. You all have heard the song Jerusalem. I'm not much of a singer. Jerusalem, no, 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 say. Excuse me, I'm not much of a singer. But basically, that song is a global hit. I think last counting is it's been streamed billions of times. If memory serves me right, it's been a minute since I counted the stats on that. But basically, this particular lawsuit has just dropped this week, a potential lawsuit being filed. And I think it's an important lesson for all artists watching, certainly the ones on the continent, but everywhere you watch. And what the allegation is by Biblos and Shamaza, the DJ, their lawyer, the written demand that was sent to Mastercraft KG's camp is that basically Mastercraft contacted Shamza, the DJ, and said, basically, come over to my studio and record. Allegedly, Shamza went over, he recorded, arranged, produced, composed the whole 9 yards. And supposedly, or allegedly, Mastercraft KG was not involved in that process at all. So he leaves the studio, and apparently, or allegedly, while he was there, Mastercraft KG, for the most part, wasn't even present. Records it. He's under the impression that if the work is to be used, all clearances will be obviously done, including, of course, getting the proper licensing or assignment of rights, if that's the direction they wanted to go for the song Jerusalem. He said to his astonishment, he finds that Mastercraft KG, instead, through his company, releases his song. Through Mastercraft KG's company, releases a song which we now know is a global hit with absolutely no permission to do so. And he also emphasizes that Biblos, one of the things he had in the song was a sample of a song by Biblos, and that needed to be cleared as well, but was never cleared by Mastercraft KG. So the hit song we're talking about is Jerusalem. And you know what's been happening ever since that song has made it and gotten that kind of global recognition? We keep seeing more and more allegations of infringement that keep coming, or some sort of dispute regarding if it's not infringement, regarding just the contractual relationships surrounding that, and people who need to be compensated not being compensated. Here's what I have to say about this. For all artists watching, and you've heard the set of facts that I just talked about, very, very critical for you to always, always remember your split sheets. Super important. If you're Shamza, the DJ, and Mastercraft KG is saying, come over to my studio, I don't care how big that talent is, right? So Beyonce, for example, when she did the Gift album, connected with a lot of African artists on the continent. I don't care how big, literally, they could be Beyonce, Jay-Z. I don't care how big that artist is. No one is going to invite you to come collabo on a song. In the recent, we see Essence, by Wizkid featuring Thames at the top. Wizkid didn't invite Thames because he thought she didn't create value. He knew she created value. Now, maybe they might not have known that song will obviously become the global hit it is. But underlying that is the value. So if you are the emerging artist, or maybe you're not the emerging artist, but in terms of your reputation, publicly or globally, or your net worth is not as high as a Beyonce or a Wizkid or David or whatever, it's still, or Mastercraft KG, doesn't matter. At the end of the day, people are contacting you because they believe you bring value, new sound, new way of composing, whatever the case may be. So do not go into a setting as talent, and those who represent you should know this, without talking business and clarifying what allocation or percentage of allocation of copyright you're owned, if at all, or if you own it right out, which probably wouldn't be the case. Maybe it's through a work for hire agreement, or maybe it's through a complete assignment of rights, or whatever the case may be. Structure that. Is it a license or is it an assignment? But do not go into a relationship and not understand the splits and the percentage that you're owed, and not even get compensated for it, and then you end up here. Now, the good thing, arguably, is that both in under South African law and certainly the U.S. law, the good thing is that if someone infringes, and they never do what they're supposed to do. The good thing is when your lawyers get involved, if that song is already out there, like the Mastercraft KG song, part of what the lawyers are asking for is an accounting. Tell us every and anywhere, all where all monies have been made, and pay us obviously what we're worth. And in addition, the scary part would be on the other side, Mastercraft KG side. One, if Shamsa, the DJ, went in and filed for an injunction, but it wouldn't make sense to do so, although that's obviously a threat of potentially stopping the song from being distributed. You want the song distributed and essentially having Mastercraft KG pay you what you're worth and pay you your value and get those royalties in. But rather than deal with all of this and maybe the lawsuit that might ensue and maybe the monies that are involved and the guarantees, you never know what happens with trial. Although with this, if there's proof of that registration of copyrighted work, even if there's no proof, because South Africa, Nigeria, certain laws don't necessarily require actual registration to pursue a lawsuit. But even if those things do not exist, you certainly can get huge compensation for that infringement. But rather than go through all this drama and craziness, do your split shits right from the onset and know your value so that when talent, major talent from Drake to Beyonce to Wizkid to Davido to everybody else, if they contact you, you're not like so overwhelmed with who they are and their talent that you forget to take care of your music business. So very, very important to stress that out. I've got Tracy Richards watching, and Tracy says true. Yes, absolutely true. Thank you for watching, Tracy Richards. Tell me where you are watching from. All right, so that is that lawsuit from South Africa. Very important. That song, Jerusalem, global hit that we are talking about. I think what I will do now is take a quick break and we'll come back. And the next thing we're going to get into is the Yeezy lawsuit. And then, of course, right after that, we'll get into the Tarantino lawsuit. Thank you for watching. You're watching the AfricaMusicLaw.com show with yours truly, Miss Uduak. And I appreciate you all staying through because we've got a lot more to cover. All right, we'll be right back. Let's take this 30-second break to get ready so that you can marinate on it and get ready for the next set of legal shenanigans that we're going to get into. All right, welcome back, everyone, to the AfricaMusicLaw.com show with yours truly, Miss Uduak. So now we're going to get into our next lineup of cases, and specifically, let's talk about the Yeezy v. Walmart Inc. case. One of the reasons I wanted to just briefly touch on this case was actually filed in June or earlier this year in June. And over time, there've been a lot of back and forth with the two brands, both on the trademark office level with challenges by Walmart against Yeezy, Kanye West trying to obviously file trademark and register his logos for the brands that he's trying to get going. But independent of that, I wanted to cover this lawsuit because it was coming back up again in the news to emphasize two key things: the difference between knockoffs and counterfeits, and the direction that Yeezy decided to go with respect to the lawsuit he's filed. And one of the things I want to emphasize also, if you haven't had a chance to go watch Drink Champs, where you have via Revolt TV on YouTube, please go watch it. And that is where Kanye West grants an interview to the host. And I just think it's so interesting to just watch him go on for like 2.5 hours or so. And then there's another follow-up part 2 that he goes on for a little over an hour. It's just watching Kanye West express himself fully without necessarily being censored or his voice edited or his statements edited is quite interesting. And I think regardless of where you fall on how you view Kanye West, I think what I admire about him is his mindset, his can do attitude. He believes he's supposed to be a billionaire, so he works towards that. He believes that, he can be president, so he runs for office. He believes in whatever it is he believes in, he does it. I think that is something that, regardless of your perspective or viewpoint on him, or how you may view his mental health issue that may affect or not affect him, the point is that we all need to adopt a mindset that is very can do and stick to that mindset, knowing that whatever it is we want to do, really, the sky is the beginning. And I think that's what I really like about Kanye West. So I encourage you to go watch that interview. So let's get into his particular lawsuit and what the allegations are of the suit that he's filed. And before I do that, let me just pull up his the particular issue that we're talking about. All right, so that is the Yeezy v. Walmart in terms of the image at. Okay, so covering that particular case, I'm just going to reference my notes here that I wrote for him. All right, so this is an action that Kanye West has filed alleging two key things: unfair competition by the defendant, Walmart Inc., and also quantum merit, which is basically unjust enrichment, that he should not be in, that mean Walmart should not be enriched because they're specifically stating that, oh, I'm getting a response quickly, just interrupting. Roxanne Gilgis says, can't find you on Facebook. That's interesting, Roxanne, because it's showing that it's streaming on Facebook. So visit both the African Music Law page and the Miss Uduak Facebook page, and you should be able to see it streaming. If not, certainly it's available for replay as well. But you're able to somehow join us with some comments here. So stay, whatever that medium is that you're using, please feel free to stay with us and continue with us here. All right, so let's get back to the Yeezy versus Walmart Inc. You can see right across the screen, I have copyright foam runner shoes, and the two particular claims that Yeezy, Kanye West, has sued Walmart is based on, first, unfair competition, and specifically under California Civil Code 17200, which prohibits any unlawful, unfair, or fraudulent business act or practice of false, deceptive, or misleading advertising. And then he's also sued under quantum merit theory, which again is unjust enrichment. Now, unlike music and unlike film, when it comes to fashion, a lot of fashion designers have a big challenge with being able to show copyright infringement. You can show copyright infringement when we're talking about, so we're not dealing with copyright infringement here, and then trademark infringement as well. He hasn't sued based on a trademark infringement and that theory, and that's why I'm taking the time to explain to you all what he's sued under, so you sort of understand it. So whenever you're talking fashion design, for the most part, under U.S. law, fashion designers do not necessarily enjoy copyright protection per se. They do in certain things. So the fabric design, for example, yes, and certain other parts of fashion can be protected. So if I created, again, a particular pattern or design and I put it on fabric, it's protected. But overall, when you're talking about the functionality or silhouette, for example, of a garment, not protected. In this instance, we're talking apparel, shoes specifically, and we've seen also trademark lawsuits, YSL versus Louis Vuitton with the whole red sole shoes. But that's not necessarily what we're talking about here. What we're talking about specifically here for purposes of Kanye West is a knockoff. Kanye West is saying, look, I specifically created something. I'm going to show you all in case you missed it. I'm going to show you that particular shoe again. So Kanye West is specifically saying, I created this amazing brand of shoes, and Walmart, you basically knocked it off. So you've knocked it off, and people are going around buying that particular brand at a cheaper price, which is obviously affecting my own brand and my own price. Now, generally, knockoffs are not illegal. However, if you do it in a way under the law that can cause people, consumers, to be misled, thinking, okay, it's Kanye West's brand, but it's actually, Walmart's, and they're going into Walmart to buy the particular shoe under the idea or belief that it is Kanye West's, then you can possibly have a case for purposes of a lawsuit filed, which is why Kanye West is going under the California Safe Code 17200 to try to say, no, it's unfair, deceptive practices, and I should be able to be compensated. And not only that, you don't get to be unjustly enriched off of basically recklessly and horribly, basically trading off what I've done, trading off my good name and goodwill. And one of the things I want to just emphasize for this particular matter, and we're basically ready to wrap it up after, is just again drawing your attention to the distinctions between the knockoffs and the counterfeit, because a lot of people get very confused whenever we're talking that. So with knockoffs, and you can see it right on the screen, you have the offenders reproduce the exact copy of the original goods, but they don't necessarily have the trademark attached to that. And as I said, that's not illegal except where there's a resemblance so as to mislead consumers. And that's Kanye West's argument, that there's a resemblance, it's misleading consumers. You can knock off if you want, but it's so close to my brand that there's no way that it's not, that you are not misleading. And then in the complaint that they filed, they've got tons and tons and tons of paperwork they show from social media of all these people going into Walmart to buy the particular brand of shoe, thinking more so it's Kanye West, but not realizing that it's actually not. So that's that. And then you have counterfeits, just to show the distinction. But the counterfeits, the offenders reproduce the exact copy of the original goods and its trademarks, and that is illegal. Okay. One of the things that brands get used to, or should get used to, is certainly getting U.S. Custom Border and Custom Patrol folks involved, where they generally, designers will show them and educate them on their products, so that if those products are being shipped from the international shores into the U.S., or just generally going from one place to another, customs can stop that illegal counterfeit goods from moving forward and saturating the marketplace. So you always see a lot of law enforcement involved when it comes to counterfeiting. But for knockoffs, they're regular, they're not illegal, unless, of course, the criteria I just talked about. So that is that for the Kanye West case. Right now, there's a pending opposition with respect to trademark applications for different brands that Kanye West is trying to pursue that I already mentioned. So this too, Walmart and Kanye West have been going back and forth with all kinds of legal shenanigans, and we'll see what happens maybe early next year in terms of the status of this particular case, whether they resolve it, and certainly at the U.S. Patent and Trademark Office, see what the outcome for the opposition that Walmart recently filed against Kanye West in trying to move forward with registering his trademark. Although the most recent update is that they currently have, Kanye West is currently put a pause on that related dispute, as well as Walmart, to try to see if they can settle things. So it'll be interesting to see if they're able to do so. All right. So the final case that I want to talk about is the Tarantino case. It's a very, very interesting case, very important case for industry stakeholders as a whole. And that's a Miramax versus Tarantino over the sale of handwritten screenplay, original copy of the Pulp Fiction as NFTs, of his hit film Pulp Fiction as NFTs. And I'll lay the facts, the contract claims, and we'll talk about why this is so important. We'll get into just briefly what NFTs are, why you should be certainly paying attention to this particular case. So the claims here are breach of contract, copyright and trademark infringement, and unfair competition. And we just saw unfair competition in the Yeezy claim, or Yeezy case against Walmart Inc. So you have an idea what unfair competition is. But this particular case is in federal court. So let's just lay it out. And I have the notes here. Hold on a sec. For this case, let's see. All right. So Let's start with the parties. The parties here are Miramax LLC. And one of the reasons when I do this analysis, I like to sort of take it step by step so you all know and come from a mindset of a trial lawyer. So you know what we're looking for when we're filing this case is the parties that are deliberately selected that you file against, and then also the causes of action. And then we sort of walk through the allegations and what is expected or not expected of both parties in trying to prove their case, and maybe they might be able to resolve it or not. So first things first, the parties, we're talking about Miramax LLC. They're a company that Tarantino has done business with. They've financed a lot of his hit movies, his blockbusters, and he's had a long-term relationship with them, and they bring that into play as part of their allegation and in their complaint that they file. And the defendants are Quentin Tarantino and his company, Visiona Romantica Inc. Now, that company is a loan-out company. When you are in the film industry, you hear a lot about loan-out companies where whether it's directors or actors, instead of directly transacting or doing business with a studio or any other third party, they will set up their companies as an LLC or a C corp, but generally as an LLC. And that LLC is treated as a loan out company where they hire their services, loaning out their services to the studios or whatever the case may be. So this is a loan out company, Visionaire Romantica Inc., that is involved in this lawsuit. And so it's Quentin Tarantino as well as his loan out company. And where are we? We're in federal court because of most of the claims and the allegations are in federal jurisdiction. So we've got the trademark infringement claim, we've got the copyright infringement claim, we've got the breach of contract matter as well that they filed. So what exactly are the defendants being sued for? You have it right here that I've talked about: breach of contract, copyright and trademark infringement, unfair competition. So what are the alleged facts? And this is where you pay very close attention to what is being said. And I'm going to share some of the notes that I've written about that. So what they're saying is, what Miramax is saying is, Tarantino recently made the announcement that he plans to auction off 7 exclusive scenes from Pulp Fiction. Pulp Fiction was released back in 1994, huge blockbuster. And he's going to do it in the form of NFTs. And the way he's doing it is, so he's had this actual handwritten screenplay before it was typed up for the typed up screenplay that ultimately went on to become Pulp Fiction. But for his handwritten screenplay that has been sitting, according to him, in his office for over 24 years, he's not done anything with it. But now that you have the NFT market or NFTs coming up now, he says to himself, based on back and forth discussions, negotiation, oh, wow, this is a good idea for me to get into this space. And the way I want to do it is with this handwritten screenplay. And I ultimately want to be able to scan it and put it on the blockchain as essentially an NFT. And all this secret aspect of the Pulp Fiction, like putting it together, the person who's going to be the recipient of that, the person who ultimately, when I mint it, the recipients will be able to have that exclusivity, in a secret form of all of the insights, etc., that I had with respect to that particular screenplay. And they can decide if they want to share it with the world or whatever they want to do with it. So that's essentially overall what it is. And to quote a specific language, each NFT contains one or more previously unknown secrets of a specific iconic scene from Pulp Fiction, and the privileged purchaser will get a hold of those secrets. So that's essentially what I've talked about. And on his website as well for this NFTs, he says the owner will enjoy the freedom of choosing between, 1, keeping the secrets to himself or herself for all eternity, sharing the secrets with a few trusted loved ones, sharing the secrets publicly with the world. So if that's the case and it's a handwritten screenplay, why is Miramax so upset to the point of filing a lawsuit? Here is their claim. They're saying essentially, Tarantino, you can't do that. The reason you can't do that is that ultimately, when we financed your movie, when we got into a relationship with you and financed your movie, Pulp Fiction, you entered into a legal agreement with us. And in that legal agreement, you granted and assigned your rights, basically all of your rights, or they use the language, nearly all of your rights. You granted and assigned nearly all of your rights to us. And yes, you did carve out, reserve some rights, which is again normal within the context of filmmaking and music and fashion, etc. When you're brokering deals, and just to back up, anytime you're in the creative space, you are ultimately monetizing your intellectual property. There are two ways to do it. You can license, which means you're giving limited permission for someone to do, distribute, sell, reproduce, etc. Your work, or and the core rights remain with you, or you can assign it, which means you give it out forever and ever and ever. It doesn't essentially come back to you, barring any statute that says it comes back to you at a particular time. But anyway, so essentially what they're saying is, excuse me, you assigned all of your rights, you gave all that to us, or nearly all of your rights, and yes, you reserve some rights, but the reservation of rights that you have is not enough, for you to be trying to mint this NFT. Mint means basically sell your original handwritten screenplay as an NFT, and in doing so, you're undermining the agreement that you got in with us. And in undermining that agreement, that affects us in the marketplace, because we certainly want to get into the NFT space. In addition, what you're effectively doing is encouraging others basically to try to subvert any kind of contracts they've had with us, because ultimately they're going to come and say, okay, maybe their handwritten screenplay or whatever the case may be, they too can do it this way. And so Miramax is saying, no, 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 you don't get to do that. And they said they tried cease and desist letter. Basically, that's the first leg before you file a lawsuit on the trademark or intellectual property side. On the non-intellectual property side, we just simply call that a demand letter. But the cease and desist letter was sent out, told him to stop, and instead he got more defiant. They essentially is what they're claiming, and move forward with trying to market, promote, and let everybody know about his upcoming sale of this NFTs. So that's essentially their allegation. And then the question becomes, well, what is the specific right that Tarantino reserved? Because it becomes crucial, right? Does he have the right to move forward with this NFT sale? Miramax is saying, no, he doesn't. Tarantino is saying, oh, heck yeah, I do. So let's look at the rights that are reserved. Tarantino, and you can read across the screen, Tarantino's reserved rights are soundtrack, album, music publishing, live performance, print publication, including without limitations, screenplay publication, making of books, etc. So their argument is, his argument ultimately is, yes, I reserved rights, and part of those rights are my screenplay publication rights, as you can see right on the screen, and that is a subset of my print publication rights. So I don't know what you're talking about, because I'm moving forward with doing what I want, what I need to do, and what I want to do with my original handwritten screenplay. So interestingly enough, Miramax says, yeah, pretty much what I was saying. You have all rights now or hereafter known. So Miramax's rights include all rights now or hereafter known in all media now or hereafter known, and that his reservation of rights did not contain any forward-looking language. I found this particular statement, do not contain any forward-looking language, very, very interesting. So what they're saying essentially is, okay, well, we've used this language, by the way, which is so common in the industry when you have those carved out rights. At some point, as technology and technological consumption patterns change, we've seen it in music, we've certainly seen it in film as well, your downloads, your streaming. One of the things major studios, major labels have done overall is starting to carve out language, this language you're seeing on the screen, that essentially gives them broad application to say, even if we don't know the technology now, or we can't foresee the technology in future, you give us that right nonetheless to still move forward when new technologies come forward, in whatever rights you've granted to us includes this new technology. And there's something to be said on whether NFTs are actually new forms of media or whether they've always existed, among other things. But basically, the Miramax is banking on the fact that the all rights now or hereafter known in all media now or hereafter known specifically allows for them to be able to put their hands on the new NFT, the attempted NFT sale that Miramax is trying. I mean, that Tarantino is trying to broker. But I think for me, it's so interesting that Tarantino. The argument is that Tarantino reserved rights do not contain any forward-looking language. I'm not sure that that's required on his part to have any forward-looking language. And so that takes us back to the rights that are reserved. Arguably, one would say that a screenplay publication, he's reserved it outright, and that's what his lawyer is saying. So he's reserved that outright. What do you mean by he doesn't have the ability to then move forward with being able to mint his NFT, specifically the hand written screenplay? That doesn't seem to make sense. But we'll get very briefly into what an NFT is. But let me go to the arguments here that I've put down for Tarantino, and then I will also talk about the arguments from Miramax. So Tarantino's argument: I reserve my rights to my screenplay publication, which is a subset of my print publication rights, which I also reserve. There's a statement put out by his attorney that essentially boils down to this: therefore, I can proceed with my NFT sales. And what I understand Miramax to be arguing, based on looking at the complaint, is you don't have a screenplay publication or print publication. You just have a one-time transaction of your NFTs. Now, this is where, for those of you, whether you watch this now during the live stream or watch it later, please feel free to leave in the comment section. And for you podcast listeners as well, feel free to leave a comment in the comment section, or email or DM, or contact us on social media, and let me know your thoughts on what you think about this argument of one-time transaction of an NFT. Because to me, I don't think it's an understanding of how NFTs work, in my perspective, because it seems to be arguing basically that an NFT is a derivative work. And I don't necessarily agree with that. I think more so NFTs should be viewed, in my opinion, as a database entry on the blockchain or in the blockchain. So that gets us to the different definitions of NFTs. And let me go right to the top here on some of the definitions and ways to consider viewing an NFT. So what is an NFT? An NFT has been defined as a non-fungible token and is a secure and unique digital token recorded on the blockchain. What is a blockchain? Actually, before I go there, let's look at other ways to view what an NFT is. Digital collectible, where you can prove its authenticity because it is unique. So what is a blockchain? I quoted Euromoney on this because I thought their definition was, succinct enough. It is a digital ledger. So think of your traditional ledger, but this time around you have a digital ledger of transactions that is duplicated and distributed across the entire network of computer systems on that blockchain, on that distributed ledger that they have, or digital ledger. And so if you're looking at the application, I tried to sort of come up with an application that you all might understand. The way I would explain this when it comes to the Tarantino case is that Tarantino has had his handwritten screenplay of Pulp Fiction for about 24 years. He will now sell it, and NFT language mint. So he'll now sell it as an NFT on the blockchain. So the screenplay will be scanned and will be on the blockchain as a digital collectible, with Tarantino going directly to his fans without worrying about Miramax and all the other gatekeepers that could potentially get in the way. All right. And then one important thing to note about NFTs, it can be digital or physically backed. So he has a digital copy of his handwritten screenplay as an NFT, and he also has a physical copy that we know he's kept for about 24 years now. The other thing is the point I was trying to make, and I thought was interesting, and I think that's the core of it. There are two key things that I think a court would have to decide if this case is not resolved through settlement. Number one is, or a court or jury, they want a jury trial. So jury will have to decide all of this. Is number one, that broad language of whether we know the technology now or in the future doesn't matter. You're essentially giving us your rights. And in giving us those rights to the unknown, to the universe, etc., then you don't get to, since the NFTs are here now, you don't get to monetize that intellectual property because you already gave us those rights. So, that's an interesting argument. But for me, that necessarily means they're treating the NFT as a copyrighted work in and of itself. So the question for me and for you watching is an NFT a derivative work, or is it just a database entry in a blockchain? I propose that it is actually a database entry in a blockchain. And I've been asking these questions and hearing members of the NFT community. Few of them have said, well, it could be both. But I think for this particular analysis, I don't know that I would agree that it is both, because the NFT itself technically has no intellectual property. It simply points you to that content, to that intellectual property. So one cannot say that something that's pointing you to an intellectual property is in and of itself a derivative work of the copyrighted screenplay. But I guess you could also argue on the flip side that in creating that digital asset, whoever creates that digital asset, it could be argued that that's IP right there. But if it is IP, what's the relevance to this case? Arguably, it would be someone else's IP that has no bearing on this particular case, because the crux of this case would be focused on that handwritten screenplay. And to the degree that you can scan it and digitally and put it on the blockchain, doesn't change the fact that those rights were reserved for the handwritten screenplay. So what's the problem? So the other question is the content, so NFT is the content it points to, i.e. the handwritten screenplay. So the question I had is the content it points to, so the NFT pointing to content, i.e. the handwritten screenplay, is that infringing on Miramax's copyright, which is the question that I'm asking here. And my answer, so far so good, based on all the pleadings I've read, so far so good that have been filed, and the arguments, I don't see it. I really don't see it. I really do believe, based on everything that even the plaintiff in this case have put out there, that those rights were reserved for the screenplay publication and just print publication as a whole. So I'm not sure that there's a strong argument to be made on the claim of breach of contract. I also don't see an argument to be made on copyright infringement. Now, what they've tried to do on the copyright infringement argument and the trademark infringement argument is independent of the NFT. I'm trying to pull up the allegations. And independent of the NFT argument and breach of contract based on that NFT, they've said that the marketing and promotions of the upcoming sale of the NFT incorporates pre-existing copyrighted work that has been assigned to them by Tarantino in not only this particular Pulp Fiction movie, but other movies they've done with Tarantino. It's been incorporated into the marketing and promotions of this particular sale. And so as a result, they're claiming copyright infringement as well as trademark infringement of some of the things that have been incorporated in that. I think that's an interesting argument. We'll see where that goes. But as to the core of the handwritten screenplay, I really do not see it. So that's basically all that I was going to cover with you all. If you have any questions or comments, certainly feel free to share with me. We went over just the highlights of some of the key stories I wanted you all to know: Davido, Moa Budu, P Square, and the Mastercraft KG case, which is a very, very interesting case of copyright infringement. Then we looked at the Yeezy case, really more so looking at the distinctions between knockoffs versus counterfeits, key emphasis I wanted to underscore there. And then we looked at the Tarantino case. So what does all of this mean, particularly the Tarantino case, for the industry at large? Well, if you're a stakeholder, certainly you want to pay attention to the NFT market. But I think that it doesn't change the fact that whenever you are talking NFTs and dealing and transacting, you're still ultimately going to come back to dealing with intellectual property issues and how you parse it out and ensure that if you have already given out based on the contractual agreements you had prior to NFTs being a thing, you go back and look at that contract and see whether you've given out all those rights or whether you haven't given out all those rights, and be able to move forward with enforcing it if it needs to be enforced, or if it's not a situation that needs to be enforced and someone is claiming it needs to be enforced. Obviously, you're going to need to go get your lawyer to help you with that. So it's going to be very interesting to pay attention to this case, because the outcome ultimately might affect every other deal in the industry. Sort of reminds me of the whole Eminem case when it came to where he sued Universal back, I think that was about 2009, with respect to whether his songs being downloaded constituted a license or distribution in the other sense of it, so that the fees that are associated with the license would have been higher rather than the other categorization that the labels or the major labels were wanting to go. So, you're going to keep seeing this kind of themes coming up over and over again. And I don't think the entertainment industry as a whole really has planned for it. So there's definitely going to be a lot of litigation, and I think that that's going to be very interesting times ahead with that. So that is essentially the synopsis of all that I want to share with you all. Thanks for those who came and commented and joined me on this, and for those of you who will watch the replay or listen on the podcast. Again, if you're interested for your own specific scenario, because this is just informational purposes, whatever the case may be, feel free to contact me at my law firm at fashionentlaw.com. Independent of that, for African Music Law, the brand, the media company, the publication, what we're doing right now, feel free to specifically sign up for our newsletter. You can subscribe to the show on all major podcast streaming platforms. You can sign up for our newsletter. You see that ticker going down there, and feel free to rate us on Apple Podcasts as well, certainly. And just visit africanmusiclaw.com for all that we encompass, including working with us, whether it's podcast licensing, advertising, partnerships, whatever the case may be. That's it from me. I will see you all next week. Next week, I think I want to take on the Alec Baldwin case. Since the case has come on, there's been so much that has been said of potential filing of criminal charges. So there are two tracks. There's a civil lawsuit. One lawsuit has been filed. There's yet another lawsuit that's just been recently filed, which is why I'm interested in also taking that on and talking about that and just breaking that down for what it means for the industry. But then there's also the potential criminal charges. We'll see if anything comes out of that. But one of the things to remember when it comes to situations like that, or situations like we've seen now, or last week, the Astroworld tragedy that we saw with Travis Scott, etc., we've got to remember that it's no longer okay to say, well, this is how we do things, right? Things do shift. And necessarily, if it's not working and it's not the right way of doing it, we must revisit it and find new ways of moving the industry forward. That's it from me. We'll talk to you all next week. Have a good one. Thanks for joining. Cheers. Bye-bye.